Good day, Crime Talk aficionados. We have another great show for you today. First, Nick Reiner has been removed from the suicide watch, so he's going to be in court tomorrow morning. The trial commences in the Uvalde school officer case. The lead prosecutor has been removed from a high-profile case in Virginia. A deputy faces additional charges in an alleged murder for hire scheme. A Florida woman charged in the shooting of not one, two former ex-husbands on the same day. Thieves target Pokémon cards? Really? Trial testimony reveals that the party mom, Shannon O'Connor, apparently was in control of the little social dynamics there in California. We've got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment down below, hit that little bell for notifications when we go live or put up new content. And yes, you can check us out on any of your favorite podcasting apps. Couple of things to update you on. First, our Amazon storefront. That's right. The Amazon storefront is back up and running with brand new products that have personally been approved by moi. So if you have an Amazon gift card for Christmas, you're exchanging something you didn't like or just realized you forgot to send a gift to somebody, use the link below. It helps support Crime Talk. Now, also yesterday, ladies and gentlemen, we told you if you purchase Crime Talk merch yesterday, we would select a lucky winner, and I would include in their order a crisp $100 bill. We had a lot of orders yesterday, and so we have randomly selected, and we will be sending to Donna from Wellstown, Michigan, a crisp $100 bill in her order for the shirt that she ordered. So if you didn't win, today's drawing, guess what? You can try again next week as well. That's pretty good. Buy a shirt, get $100 back in exchange. That'll go out today. Donna, congratulations. You did it. Also, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. Find out information about anybody coming into your life. You're going to find out phone numbers, email addresses, social media presence. You're going to be able to check them out. Find out if they're married, divorced, liens, judgments, criminal record. Are they on one of those sex offender registries? Check them out. Go to crimetalksearch.com. You're going to be happy you did. And also hit the link down below for merch. And who knows, maybe next week you too could win $100. All right, let's go ahead and get to the docket today. So it is Tuesday, January 6, 2026. And first on the docket, Nick Reiner. Guess what? He has been removed from suicide watch, which means he is going to court tomorrow. So Nick Reiner, the son of filmmaker Rob Reiner and photographer Michelle Singer Reiner, has been removed from the suicide watch while he is in custody there at the Twin Towers Correctional Facility in downtown Los Angeles. Now, Reiner is going to go to court tomorrow and face 2 counts of first-degree murder with special circumstances, alleging multiple murders and the use of a knife in the fatal stabbing of his parents back on December 14th of last year. That all took place in their Brentwood, California home. Now, he remains held without bail in high observation housing designated for individuals with mental health concerns, where he is monitored every 15 minutes and kept in solitary confinement. Authorities have confirmed that the protective anti-suicide smock previously required is no longer in use. Now, during an earlier court appearance, Reiner appeared disheveled and spoke softly, as observed by court reporters and what we saw on the video. Now, courtroom sketches from the hearing depict him in this custody attire, obviously, and reports indicate that Reiner had been diagnosed with schizophrenia prior to the incident, and adjustments to his medication in the preceding weeks allegedly, possibly contributed to some erratic behavior. Well, prosecutors have described the case as particularly challenging due to the intrafamilial nature, and the Los Angeles County District Attorney Nathan Hochman has yet to announce whether the death penalty will be sought. My guess is, since he will have to consult with the relatives of Nick Reiner, his brother and sister, and given the fact that they would probably honor his father's request the death penalty not be imposed since he was opposed to the death penalty, it seems highly unlikely that that would be the case. Throw on top all of his mental health issues, it'd be pretty unlikely that a jury would convict and impose the death penalty. I think a jury can convict, but I find it hard to believe that the death penalty would be imposed. So Reiner's arraignment, previously postponed to allow the defense additional time for preparation, is scheduled for tomorrow, January 7th, and we're going to try to bring it to you live as well. So it is scheduled for an arraignment. So what does that mean? Well, under California law, if you're going to enter a plea of not guilty by reason of insanity, you have to do that at an arraignment. Now, it can be done at a later state of the process if good cause is shown. Now, so tomorrow, more than likely, at least a not guilty plea will be entered, and one of not guilty by reason of insanity could be entered as well, or they could ask for permission to do it at a later date. But that's the normal course. It's due at the arraignment. So we'll see. Another issue that can be raised tomorrow, which could delay the proceedings even further, is if the defense were to raise competency. Competency is different from not guilty by reason of insanity, although they are kind of connected in some little way, Rob. If they weren't competent when they were arrested, maybe they weren't competent at the time. But now it depends on competency is, can you explain, or does the defendant understand what's going on? Does he understand the nature of the charges against him? Does he understand the role of the individuals in the courtroom, the roles that they play? What does the prosecutor do? What is the defense attorney supposed to do? What's the role of the judge? What's the role of the jury? Pretty low standard for somebody to understand that. Generally, if you can fog a mirror, you're usually competent. And it's usually the ones that, the truly crazy ones don't want to be comped because they've previously been to like a state hospital or something along those lines. It's usually the fakers that want to raise competency and say, ooh, the voices are talking to me. So we'll see what happens tomorrow, and we'll discuss it with you as well. Next on the docket, let's jump to Corpus Christi, Texas. Opening statements were delivered this morning in the county courthouse there, marking the commencement of the first criminal trial stemming from the tragic law enforcement response to the May 24th, 2022 mass shooting at the Robb Elementary School in Uvalde, Texas. Now, the former Uvalde Consolidated Independent School District police officer Adrian Gonzalez faces 29 felony counts of child endangerment and abandonment, charges that allege his failure to confront the gunman placed student in imminent danger. Now, the shooting claimed the lives of 19 children and 2 teachers, along with the gunman. Salvador Ramos remaining active in connected classrooms for over 77 minutes, despite the arrival of nearly 400 police officers from various agencies. Gonzalez, a 10-year veteran assigned primarily to the high school and one of the initial responders, entered a not guilty plea. He is one of only 2 officers criminally charged in connection with the incident, and former Uvalde police chief Pete Arredondo faces similar accusations, though his trial remains unscheduled. Now, the jury selection process was, it was a marathon for sure. Following an exhaustive 12-hour jury selection on January 5th, the presiding judge, Sid Harrell, seated 12 jurors and 4 alternates from a pool of nearly 450 potential jurors. The trial was relocated from Uvalde to Corpus Christi due to concerns over securing an impartial jury amid widespread media coverage and community trauma. The judge anticipates the proceedings will take approximately 2 weeks, with prosecutors planning to present around 60 witnesses, including officers, dispatch individuals, school staff, and possibly victims' family members. Several relatives of the deceased traveled 3 hours from Uvalde to attend the trial. Now, prior to opening statements, the defense sought to exclude graphic photos of victims' injuries, arguing that they would unduly prejudice the jury by evoking emotion rather than proving Gonzalez's culpability. The judge reviewed the images, describing them as horrific, but ruled their probative value demonstrates endangerment under Texas child endangerment statute, and that outweighed the potential prejudice, right? That's a 403 analysis that the defense made, saying, Judge, this may be probative, but the prejudicial effect far outweighs any probative value. And the judge says, nope, they're graphic. Yep, they're prejudicial, but the probative value is there. And guess what? We're showing the incident that took place, and they're alleging that this officer was responsible for this. So that's why it's coming in. Anyway, he did reserve the right to limit or exclude specific photos during testimony later in the trial, and victims may be referred to as such in court, but not directly attributable to Mr. Gonzalez's actions. Well, the prosecution, they say that the officer failed to act despite training and awareness that Uvalde County District Attorney Christina Mitchell opened by reading the indictment, which accused Gonzalez of knowing the shooter's approximate location after hearing gunfire, yet failing to engage, distract, or impede him. Special Prosecutor Bill Turner, visibly emotional, evoked the end of school year scene at Robb Elementary where classes were viewing films. He detailed Ramos crashing his vehicle into a culvert outside the school before entering and firing over 60 rounds within the classrooms, 111 and 112 within 90 seconds. Turner asserted a teacher informed Gonzalez of the gunman's position in the parking lot, prompting a radio description, yet Gonzalez refrained from pursuit as shots rang out. He was not aware Adrian Gonzalez was going to commit suicide. Turner emphasized noting Gonzalez merely relayed information via radio despite his active shooter training. He alleged Gonzalez entered the building only after the shooter had barricaded himself, allowing the slaughter to unfold unchecked. Well, the defense has a different scenario. Defense attorney Jason Goss and Nico LaHood countered that Gonzalez operated in a rapidly evolving, confusing environment, doing the best he could with what he knew. And using an enlarged aerial map of the school, Goss clarified Gonzalez was at a nearby park during an initial 1050 radio code for a vehicle accident, not a shooting alert. Robb Elementary lacked a dedicated officer, and upon arriving just before 11:32 a.m., Gonzalez mistook a fleeing teacher for a potential threat, while the gunman evaded detection on the building's west side. The attorneys outlined a precise timeline. Ramos allegedly shot his grandmother around 11:28 a.m., crashed shortly after, and entered via an unlocked door by 11:33 a.m. Echoing gunshots misled officers, radios malfunctioned indoors, and former Chief Arredondo directed Gonzalez to exit and summon SWAT. They stressed Gonzalez broadcasted updates entering the school, facing gunfire, aided evacuations, and fully cooperated with post-incident probes. The monster that hurt those children is dead, Goss told jurors, warning of emotionally manipulative evidence while urging focus on facts over hindsight. LaHood reinforced the fluid chaos, rejecting prosecutorial generalities. So obviously this trial is going to be a test for accountability in an active shooting scenario, highlighting training protocols and command failures and scrutinizing multiple investigations. Now, it just shows you that how things have changed. For example, the Columbine shooting obviously took place here in Columbine, Colorado, at that high school back in 1999, I believe it was. And in that particular case, the police all stayed outside when Harris and Klebold went in and shot and used explosives that they had made in their basement. No police officer was prosecuted. His parents weren't prosecuted. Things have changed, ladies and gentlemen. Things have changed. It's going to be an interesting scenario to see if the emotion overcomes the jurors and they think that somebody needs to be held accountable, or whether it was just, a fluid situation where nobody knew exactly what was going on. Now, obviously, the training these days is you go in, you confront, locate, and kill the bad guy, not sit outside and wait. And as you may recall, in that particular case, at some point, an officer showed up and basically said, "Follow me, let's go," and went into the school and found the shooter had already taken his own life. But he went in while everybody else sat back and waited. So, was he a coward? Was he just being a good police officer? Who knows? I guess the jury will tell us in a couple of weeks. Next on the docket, a prosecutor was removed from a homicide case for, let's just say, some personal legal issues. So let's jump to Fairfax County, Virginia. And there's been a significant development in the ongoing double homicide case involving Brendan Banfield. The lead prosecutor has been reassigned following an incident involving some public alcohol consumption. So the trial, which has garnered a lot of attention, has been postponed until this month. And Eric Klingon, a deputy Commonwealth attorney in Fairfax County, was removed from the case after being cited for drinking in public. And it's not that he was just, late at night sitting in a park. No, this occurred on August 8th of last year at 8 a.m. when the Fairfax County police officers discovered Klingon consuming alcoholic beverages beside his parked car in a parking lot behind a strip mall in Centerville. Now, body cam footage documented officers finding an open beer bottle on the hood of his car and an empty one nearby with the beverage noted for its high alcohol content. Now, during the encounter, the prosecutor informed officers of his intention to proceed to work, but they advised him against it. Now, a complaint had reported observing Klingon's vehicle in the area regularly and noted instances of drinking. Officers issued a citation but did not conduct a sobriety test or place him in handcuffs. Instead, they transported him home in the front seat of a police car, with one officer expressing intent to assist him and given his professional position. Following the event, though, the prosecutor was placed on leave by the Fairfax County Commonwealth Attorney's Office to address a personal matter. The office has not provided further comment on the implications for the Banfield case, and the homicide case centers on Brendan Banfield, accused of murdering his wife, Christine, and Joseph Ryan in a plot allegedly involving the family's au pair, Julian Perez Megalhas. Prosecutors have presented evidence indicating an extramarital relationship between Banfield and Megalhas, including photographs of the pair together in locations such as Bayshore, New York, a pub, concert hall, and what appears to be a bathtub or hot tub. One such image was reportedly displayed on a nightstand in the Banfield residence. Additional evidence includes records of Banfield and Megalhas visiting a gun range in the months prior to the killing, and police allege that the pair created a fictitious account on a fetish website to entice Ryan to the home as part of a premeditated scheme. Now, the au pair has since entered a guilty plea to manslaughter under a plea agreement with the county. And during a court hearing back in October of last year, prosecutors outlined these exhibits leading to the trial's rescheduling. The case has been set to commence the following week. Now, the incident marks the second time in recent years that a senior prosecutor from the Fairfax County Commonwealth's office, led by Steve Descano, has faced some scrutiny related to alcohol consumption. Back in June of 2023, Ashley Landers Sutton, then a supervising attorney handled major crimes, was involved in a reported trespassing event at a bar in Manassas, where she refused to leave after requests from security and police officers. Officers responded to Klingon citations reference the prior Manassas occurring during their deliberations. Upon updates on Klingon's legal proceedings and the Banfield trial will obviously be monitored as developments occur. It's going to be an interesting case. And, when new prosecutors come in, sometimes it's a smooth flowing thing, and sometimes it's not. There's going to be multiple people on that case, and they'll be able to do it. But as we talked about, the other day, day drinking at 8 a.m. kind of admits maybe you got yourself a bit of a problem. And if you're a prosecutor and, you're supposed to follow the law, you don't get a free pass. But apparently this one did. But hopefully he went off and took care of what he needed to take care of. I've seen alcohol ruin so many people's lives over the years, and particularly in high stress environments. Probably one of the reasons that, I don't drink, of course, come from a long line of alcoholics in our family. So that's one reason not to do it. But two, you see it where people come home and they're going to have a drink, and then one drink turns into 2 to 3 because they had a stressful day. Well, every day is stressful. And then it's 3 to 4 in it every day. Next thing you know, they hiding bottles in their desk drawer, and it just ends ugly. So I hope the Deputy DA gets the help he needs because it's certainly not worth losing his career over. I've seen many attorneys over the years lose their law licenses if they couldn't control their drinking. Next, a Texas County deputy faces some additional charges in a murder-for-hire scheme. LaMarcus Smith, remember we've talked about him. He's a 39-year-old former deputy with the Harris County Constable Precinct number 4, and he's been charged with solicitation to commit capital murder involving remuneration. That's money. Anyway, the new accusation relates to claims that he attempted to arrange the killing of the husband of a woman with whom he was allegedly involved in an extramarital affair. The charge emerges from the court records in the Fort Bend County, where Smith is already detained on murder charges stemming from the May 2024 death of his wife, Laura Smith, a 37-year-old educator employed by the Lamar Consolidated Independent School District. Now, police discovered Laura Smith stabbed to death in the couple's residence on Snowbell Court back in Richmond on May 27th of 2024, following a welfare check initiated by her sister. Smith was arrested on November 10th of 2025, more than 18 months after the incident, and faces an additional count of fraudulent possession of identifying information. Bonds have been set at $500,000 for the murder charge and $7,500 for the fraud charge. Now, prosecutors assert that the solicitation plot occurred approximately 2 months after Laura Smith's death, and documents indicate that Smith allegedly sought to hire an individual to eliminate the targeted man, offering payment reportedly ranging from $40,000 to $50,000. Now, these details were reportedly relayed to investigators by members of the Smith's family. Now, the new charge is linked to prior allegations of insurance fraud in which Smith is accused of impersonating the affair's partner's husband during communications with an insurance provider to modify policy details. Evidence supporting the affair includes extensive communications, matching tattoos, and other items uncovered during the investigation. In a separate development, a Fort Bend County judge issued a gag order on December 30th, restricting public comments by Smith and the complainant in the fraud case, the husband named in the alleged plot. Now, the order followed the complainant's interview with media outlet, which Smith's defense argued could prejudice potential jurors. And it also referenced a handwritten letter Smith sent to a local news station from jail, reportedly without his attorney's approval, in response to public statements, which of course could be a statement against his own interests. So it comes in. It's an admission by a party opponent. Now, while incarcerated, Smith has proclaimed his innocence regarding his wife's death, questioning aspects of the forensic evidence and investigative timeline in communications verified by police. The case continues to unfold with ongoing proceedings in the Fort Bend County there, and allegations remain under review, and Smith is presumed innocent until proven otherwise. Next, a Florida woman is charged in a fatal shooting of not one, but two husbands on the same day. That's efficiency. So police in Florida have accused a 51-year-old woman from Citrus County of fatally shooting her two ex-husbands in separate incidents on December 17th of last year, spanning Hillsborough and Manatee counties. Please meet Susan Erica Avalon, who faces charges of first-degree murder in Manatee County related to the death of her first ex-husband, a 54-year-old resident of Bradenton, and prosecutors there are collaborating with the state's attorney's office to pursue the death penalty. Additional charges are anticipated in Hillsborough County for the killing of her second ex-husband in Tampa. Now, the sequence of events began earlier in the day in Tampa, where investigators believe Avalon forced entry into her second ex-husband's residence and shot him multiple times, resulting in him being dead. She then reportedly traveled across the Sunshine Skyway Bridge into Manatee County. In Bradenton, shortly before 3 p.m., deputies responded to a residence in the Heritage Harbor neighborhood after the report of the shooting. The victim, who had been married to Avalon for approximately 11 years and shared a 15-year-old daughter with her, sustained gunshot wounds upon answering his door. He identified his ex-wife as the possible shooter before being transported to the hospital, where he later died of his injuries. Dying declaration. It's coming in. Now, evidence indicates Avalon obtained a takeout order from a nearby Panera Bread restaurant without payment, using it as a pretext to prompt the victim to open the door. Surveillance footage captured her taking the food, and she allegedly fired immediately upon opening the door. The couple's teenager daughter, present in the home, heard the gunshot and observed a masked individual fleeing in a silver Honda Odyssey minivan. License plate tracking led authorities to Avalon's residence in Citrus County, and upon arrival, detectives observed her cleaning the vehicle with bleach, because that's normal. Anyway, when informed they wished to discuss her ex-husband, she reportedly inquired, "Which one?" This response prompted a welfare check in Tampa, revealing the second victim's body. Prior disputes between Avalon and the Bradenton victim included an ongoing child custody issue and approximately $4,000 in unpaid child support. Investigators described the acts as premeditated and targeted, noting the brazen nature of the afternoon shooting in a busy residential area. Now, the Manatee County Sheriff's Office is leading the investigation and coordinating with the Tampa Police Department. The murder weapon has not been recovered, and searches of Avalon's vehicle continue. Avalon was arrested on December 18th and remains in custody without bond, pending further proceedings. Now, this case involves multiple children from Avalon's previous marriages, and obviously the profound impact on the family as well. Police continue to gather information, and their investigation is going to proceed in both jurisdictions. Not one, but two. We'd like to talk to you about your dead husband. Which one? I think the spidey senses go off with the police and say, we better go check the other one too. Next, some thieves target some valuable Pokémon trading cards. Police are investigating two separate thefts of high-value Pokémon trading cards that occurred on January 4th and 5th of this year, resulting in combined losses estimated in the hundreds of thousands of dollars, involving a burglary at a Simi Valley card shop and the other, an armed robbery in West Los Angeles, have raised concerns about a potential organized pattern targeting collectible card businesses in the region. Now, in the early hours of January 5th, approximately 5 masked suspects broke into the Simi Sports Cards located on Erringer Road in Simi Valley. Surveillance footage captured the group forcing entry and rapidly smashing display cases to access the inventory. Despite active security alarms, the thieves filled bags with Pokemon and sports trading cards before fleeing the scene in under 5 minutes. The store owner, a guy by the name of Jake Miller, estimated the stolen merchandise is worth about $50,000, noting that the perpetrators focused on volume rather than high-priced individual items. This marks the second burglary at the store since its opening about 2 years ago, following a prior incident back in April of 2025 that resulted in approximately $10,000 in losses. Later that evening, around 10 p.m., a customer exiting RWT Collectives, a hobby shop in Sawtell neighborhood of West Los Angeles, was confronted by armed suspects in an underground parking garage. Reports indicate the two individuals, one wielding a handgun, demanded and seized a collection of rare Pokemon cards valued at approximately $300,000 to $500,000. The victim, a regular at the shop carrying a personal collection, was reportedly followed from the premises before the robbery occurred. Police, including the Simi Valley Police Department and the Los Angeles Police Department, are examining possible links between the two events, given the proximity in time and focus on Pokemon cards. Now, Miller has suggested the involvement of an organized group, citing several similar thefts at card shops across Southern California in recent months. These cards are particularly attractive to thieves due to their rising market value and relative ease of resale through convention or private transactions, as they're difficult to trace without any serial numbers. No arrests have been made, and the investigation is ongoing. Collectible card shop owners in the area are urged to enhance security measures. Indeed. Now, I remember my son used to have these Pokemon cards. He had them all sorted out. I have no idea where they are. They could be in a garage somewhere. I don't know. But who knows? We could be rich, apparently. Who knows? Next on the docket, the party mom trial continues. So the proceedings resumed on January 5th, yesterday, in the Santa Clara County Superior Court for the high-profile trial of Shannon O'Connor, the 50-year-old resident of Los Gatos, known to media reports as the Party Mom. Now, O'Connor faces a grand jury indictment of 63 counts comprising 20 felonies, primarily child endangerment and aiding or abetting sexual assault on minors, and 43 misdemeanors, including furnishing alcohol to underage individuals. The charges stem from a series of clandestine gatherings at her $4 million hillside mansion between the summer of 2020 and 2021, where prosecutors allege that she supplied excessive alcohol to the Los Gatos High School freshmen, leading to instances of severe intoxication, vomiting, unconsciousness, and non-consensual sexual encounters among attendees, some as young as 13 or 14 years old. Now, a key witness identified in court as John Doe number 5 provided detailed testimony Monday before Judge Elizabeth Peterson, describing O'Connor's central role in curating an exclusive social circle among the students. The former students, now in his late teens, recounted attending his first event back in September of 2020 at O'Connor's home, and despite having no prior experience with alcohol, he consumed 8 beers after O'Connor's son, referred to as John Doe 3, directed him to cases of beer concealed in a garage laundry basket under a tarp, hidden from O'Connor's husband. Parties proceeded only after the husbands departed, with O'Connor instructing attendees to avoid spills or reckless behavior to evade detection, explicitly warning of potential criminal repercussions if, well, the party was discovered. John Doe 5 described O'Connor, despite the significant age disparity, as integrating seamlessly into the popular group, akin to a peer. She reportedly vetted guests via Snapchat group chats, admitting her son's football teammates and select girls deemed trustworthy for maintaining secrecy, while excluding others labeled as untrustworthy, thereby isolating them socially. Subsequent events, including Halloween and John Doe's 3 birthday celebration, featured designated downstairs bedrooms for sexual activities, though the witnesses stated he faced no direct pressure from O'Connor to participate. He ceased attending a Halloween party involving 30 minors, where heavy drinking resulted in vomiting and one girl's unconsciousness. He returned home severely impaired, shirtless, shoeless, and after 10 drinks, prompting his parents to ground him for a month following a search of his phone. Now, the prosecutor's allegations and some contrasting accounts took place as well. Deputy District Attorney Joanna Lee presented videos and photographs to the jury depicting O'Connor's distributing alcohol to minors and scenes of apparent unconsciousness, such as a girl lying supine on the floor amid stranding teens. Prosecutors assert that O'Connor's actions were motivated by an unnatural or abnormal sexual interest in minors, deriving personal gratification from witnessing assaults. A notable allegation involves a New Year's Eve incident in her jacuzzi, where a boy allegedly assaulted Jane Doe number 3 while she struggled to keep her head above water due to being so drunk. Prior victims' testimonies from Jane Doe have described lasting trauma, with one stating that O'Connor tore my life apart. The narrative contrasts with John Doe 5's depiction of O'Connor as a conversational friend, discussed sex openly, whom he retrospectively viewed as pretty weird for her peer-like status. Earlier trial phases initiated back in December of last year after multiple delays, including jailhouse calls where O'Connor urged her son not to cooperate with the police and rejected a plea deal carrying a 17-year sentence, have featured over 40 anticipated witnesses and 18 victims. So this all started back in October of 2021 when O'Connor has remained in custody since then without bail for over 4 years. Her appearance has evolved from the blonde dyed hair in mugshots to a natural dark brown in a side ponytail, paired with a black suit and glasses during the testimony that's been provided. A 2023 grand jury indictment escalated charges from the initial filings, bypassing a protracted preliminary hearing marred by health issues and attorney changes, and she entered a not guilty plea on all counts and she now faces up to 31 years in prison if she's convicted. The trial was paused briefly due to juror illness, and like I said, it continues. Prosecutors emphasized that O'Connor's deliberate concealment from parents, police, and her spouse, fostering an environment of extreme risk to vulnerable adolescents during the COVID-19 pandemic. The cool moms, everybody wants to be cool until, somebody goes home drunk and they're unconscious. It's never a good scenario. Had a case years ago where people wanted to be the cool kids, hanging out with the cool parents and providing alcohol until somebody got drunk and drove home and collided head on with another car, killing several people between the cars. And then the parents were all like, why are they coming after us? We just, provided the alcohol. Well, because they were providing alcohol to minors and, they were going to lose everything. Obviously being criminally charged, but on top of that, the civil lawsuits were literally going to bankrupt them. So don't be the cool parents, be good parents and say no. All right. All right. Next on the docket, CrimeTalkPrep.com is back, ladies and gentlemen. So in obviously an era marked by increased uncertainty, the world faces significant challenges from natural disasters to civil unrest. Recent events include severe flooding across various regions, domestic protests that escalated into disturbance, but it underscores the importance of self-reliance when crisis occurs. Whether prolonged power outages from winter storms, delayed government response to flood-affected areas, or disruptions from social tensions, individuals and families may find themselves without immediate external assistance for days or weeks. Preparation is a prudent measure, not an expression of undue concern. It empowers one to maintain calm and focus on family safety amid crisis. So go to Crime Talk Prep and go to crimetalkprep.com and it'll take you to My Patriot Supply, an established provider of emergency preparedness products and has served over 3 million American families. Trusted for its reliability, the company offers solutions designed for long-term resilience. 5 reasons why millions choose My Patriot Supply. Peace of mind in crisis. Durable, high-quality food. It's going to provide nutrition, super value. It's manufactured in the United States. These products offer hearty, affordable options without compromising standards. Ongoing support. They have been around and provide service for over 25 years. And there is a 25-year disaster replacement warranty. The company stands by customers in actual emergencies. So being self-sufficient ensures the ability to safeguard oneself and loved ones, regardless of external circumstances. Preparation fosters security in an unpredictable environment. Next on the docket, this day in legal history. 1879, January 6, 1879, Supreme Court, Reynolds v. United States. Well, what does the Supreme Court rule? The court upheld a federal anti-bigamy conviction, drawing a lasting distinction between protected religious beliefs and punishable conduct. It's one of the foundational early cases shaping modern free exercise doctrine. On this date, January 6, 1912, President William Howard Taft issues the formal proclamation declaring New Mexico's admission complete, making it the 47th state into the United States a core constitutional legal mechanism for expanding the Union. January 6, 1964, the United States Supreme Court heard oral arguments in the landmark case of First Amendment issues, New York Times versus Sullivan. This session marked the beginning of arguments in the matters that also went into the next day, and it has to do with, well, the law that we know is today as it relates to defamation. How about a legal quote of the day? How about in the government of this Commonwealth, the legislative department shall never exercise the executive. The judicial shall never exercise the legislative and judicial powers, or either of them, to the end it may be a government of laws and not of men. That's right. This provision establishes the separation of powers as a safeguard against arbitrary authority ensuring that governments is bound by impartial laws rather than the whims of individuals. The phrase "a government of laws and not of men" has profoundly influenced American jurisprudence, embodying the rule of law and the foundational idea that all persons, including those in positions of power, are subject to legal accountability. Another one very related to that was President Theodore Roosevelt in 1903 says, quote, "No man is above the law and no man is below it, nor do we ask any man's permission when we require him to obey it." Once again, underscores the equal application of the law across all levels of society, reinforcing the democratic commitment to equality before the law. And finally, our dumb criminal of the day. Let's go down to Gwinnett County, Georgia. Now, in a caper that sounds more like a fever dream than a police report, a man draped solely in a tablecloth allegedly turned a quiet Atlanta suburb into his personal joyriding playground last month, only to be pulled over and apprehended by a quick-thinking officer. Now, this little saga began on December 2nd when the Gwinnett County Police responded to a report of a stolen car, apparently linked to Mackenzie Call. Officers located the abandoned car later that day, but Call had vanished on foot. Curiously, investigators noted evidence suggesting he might have inhaled or encountered some unruly chemicals inside the vehicle, perhaps explaining the wardrobe malfunction that followed. As the manhunt unfolded, frantic 911 calls flooded in from startled residents. A man fitting Call's description was dashing through the neighborhood, clad in nothing more than a makeshift tablecloth toga, frantically tugging at a car door in search of his next ride. The plot thickened when the impromptu fashion icon reportedly slipped into a nearby home, snatched the keys of a luxurious Mercedes-Benz, and peeled away in style, or what passed for it under the circumstances. Fortunately for law and order, and unfortunately for our anti-hero, police swiftly spotted the swiped sedan, initiated a traffic stop, and took Call into custody without further drama. Now, Call faces a laundry list of charges, including theft by taking, first-degree burglary, entering a vehicle with intent to commit theft, loitering and prowling, and driving without a valid driver's license. That's the one that's going to get him. Anyway, he's scheduled to appear in court in the coming weeks, and while the motive remains as opaque as the tablecloth's coverage, one thing is clear in the annals of Georgia crime: this one takes the linen for the most creative undressed escapade. All right, ladies and gentlemen, that's all we have for you today. Thanks for joining us. We'll see you next time, and remember, the Constitution matters.